Hello, everybody.
Court will call State of Kansas versus Caleb Crane, 24 CR 197. Announce appearances.
Thank you, Your Honor. May it please the court. The state of Kansas appears by the Ellis County Attorney Robert Anderson Jr. The defendant Caleb Crane appears via Zoom and pro se, Your Honor.
Mr. Crane, you previously told Judge Flax that you wish to represent yourself and proceed pro se. You're on mute again, Mr. Crane. You're going to need to unmute yourself. Thank you. Did you hear what I said?
Yes, sir.
Do you still wish to represent yourself?
Yes, sir.
You understand that you have the right to a court-appointed attorney if you qualify?
Yes, sir.
But you wish to represent yourself?
Yes, sir.
I know Judge Flax explains these things thoroughly, and you're going to hear this every time from the judges, because generally people that represent themselves don't do a very good job, okay? It is a complicated process, rules of evidence, procedure, those types of things. Lay people have difficulty handling that. And you do this at your own peril. You understand that?
Yes, sir.
In other words, I cannot assist you. I can't say, Mr. Crane, here's how you get that evidence in, or Mr. Crane, you shouldn't do that. This could come back to harm your case. You understand all that, correct?
Correct.
You do. All right. And knowing all that, and that you have the right, if you qualify, because I'd have to look at your financial affidavit, to court-appointed counsel, you still wish to represent yourself.
Correct.
All right. I believe I looked at the file in preparation. You signed a written waiver of attorney, did you not?
Yeah, because I was gonna get a attorney at first, but I'm proceeding with representing myself.
Okay. And it shows that you signed that. It looks like in front of Judge Flax on October 3rd.
Correct.
All right. And let's go over it again. You have the right to be represented by an attorney. You understand that? Yes?
Yes.
If you're without the funds necessary to hire a lawyer and wish to have one appointed, the court could appoint one if you qualify. You understand that?
Yes, sir.
You're charged with a level 8 non-person felony, which carries a potential sentence of anywhere from a minimum of 7 months to a maximum of 23 months and a potential fine of up to $100,000. You understand that?
Understood. Yes.
I already mentioned this. I'll repeat it. If you represent yourself, you're held to the same standard as a lawyer. You understand that?
Yes.
All right. We can't assist you in any way nor explain the rules to you. You're required to know those on your own. You understand all that?
Yes.
And if this goes to trial, Mr. Crane, you also have the right to ask the court to appoint what's called standby counsel. And we'll talk about that as it gets closer to a trial date. Today, we are scheduled for arraignment. Do you know what an arraignment is?
Yes.
What's your understanding of an arraignment?
Basically, it's like we going over what we went over in the prelim, basically.
Not exactly, but yeah, there's some of that similarity. What an arraignment is the first stage of a criminal case where you formally enter a plea. You can plead guilty, not guilty, no contest, or you can stand mute, refuse to say anything. There's no penalty for that. And then if you do that, the court on your behalf enters a not guilty plea. That's what happens at arraignment. You understand that?
Yes. Before we begin, I would like to state on the record, for the record, I had filed a motion through the court, through the USPS. My service number is 9589-0710-5270-1868-199063. It said y'all wouldn't get it yet. It's supposed to be delivered sometime today.
What kind of motion is it?
It's a oral motion.
Well, no, it'd be a written motion if you sent it in writing, but what is the motion?
Motion to dismiss an objection.
You have a motion to dismiss the case?
Correct. It should be there sometime today.
Yeah, it's not here yet. Unless the clerks have received it, it's not in the court file yet. So you
Yeah,
have a motion to dismiss that you have sent to be filed.
correct.
All right, because of that, we can't do arraignment today. We'll have, Mr. Anderson and I will need to review that, and we'll need to schedule that for a hearing. So we will not be able to do arraignment today.
Okay.
Now, what we are going to do, Sandy, would you join us? Sandy is my administrative assistant. She does all my scheduling. Sandy, because Mr. Crane has sent a motion to dismiss, we'll need to schedule that for hearing before arraignment. But in case it's not received or there's an issue, we need to set a status conference. Let's do that about 2 weeks down the road.
So Judge, I'm just gonna throw this out to you and you can tell me how you want to proceed. Obviously, you know, I've been meeting with Curtis this morning, and so we were listening to this arraignment. This is a case that Curtis is going to have a conflict with. He represents the co-defendant in this case.
Okay.
Do we want to go forward with you? Do we want to move this over to Judge Dries? How do you want to proceed?
That would be good grounds to move this to Judge Dries. All right, Mr. Crane, I am retiring. I'm going off the bench January 13th. A new judge is taking over. The new judge is meeting with my AA today, and he represents your co-defendant, so he can't have this case. So you're going to get assigned to the other district judge, which is Judge Dries.
Yeah, I was aware of that.
You were? Okay, good.
Yeah.
You knew more than I did then. That's great. Because that's the first I became aware of it. So, Sandy, I'm going to leave and let you remain with Mr. Crane and Mr. Anderson. I don't know whether you're going to have Jessica join in, whether you what we need to do, but there's a motion to dismiss that Judge Dries will need to take up and prior to arraignment.
Okay, I will call her right now and see if she can just hop on and maybe take over.
All right. So, Mr. Crane, you remain. I'm going to leave. Mr. Anderson will remain, and Sandy will take over and either get Judge Dries' administrative assistant on this to schedule a status conference. The status will be for them to review the motion to see if it's going to require evidence, what the issues are, how long it's going to take to schedule for a hearing, and that hearing will need to be conducted before the arraignment. Understood?
Understood.
Do you have any questions?
So you want me to just sit in this call?
Yes, you need to remain. She's looking right now to see whether Judge Dries' administrative assistant can join us, because we need to schedule that status conference so we'll know how much time to set aside on the motion to dismiss.
Okay, that's what I was just trying to make sure about.
And since we haven't seen the motion to dismiss, there's no way for us to know.
No problem.
My AA is going to schedule that.
What's your name?
Caleb Crane. I said I wasn't expecting anybody.
Okay. I had asked if you were Caleb Crane.
Oh, my bad. I thought you said were you expecting somebody, Caleb Crane?
Oh, that would have been the next question. You anticipated one question ahead. Okay, so you are Caleb Crane. Okay, and you're not anticipating anyone else for this hearing. Okay. This is in the District Court of Ellis County, Kansas, case number 24 CR 197, State of Kansas versus Caleb Crane. If you would announce your appearances, please.
May it please the court, the state of Kansas appears through Assistant Ellis County Attorney Joshua Becker. Mr. Crane appears on Zoom and pro se.
And Mr. Crane, you understand that this hearing is being conducted by Zoom rather than in person. Is it your request that we do this by Zoom rather than in person?
Correct.
Yes?
Correct.
Okay. And you understand you could come to Ellis County and have this hearing in person if you'd like.
Correct.
Okay. And you also understand that because it's by Zoom, it's also being broadcast.
Correct.
Okay.
What was her name? You can continue. I'm sorry about that.
And further, Mr. Crane, you're representing yourself pro se,
Right.
and it's your desire to represent yourself pro se.
Right.
And Judge Fox gave you warnings before preliminary, and I gave you warnings before the last hearing that it's in your best interest to have an attorney. But it's your desire to represent yourself. Okay. I'm sorry, I didn't hear that last answer.
That's correct.
Okay. At the last hearing, we dealt with your appeal of the preliminary hearing bindover. Today, we're scheduled for the hearing on your motion to suppress, Mr. Crane. And I note, Mr. Becker, you had filed a motion to continue. Is that just a prophylactic motion, or do you need a continuance?
Your Honor, we don't need a continuance. That was more of a prophylactic. Given the notice of appeal that has been filed, we just wanted to make sure that the court was aware and still wish to proceed.
Okay. Mr. Crane, you filed a notice of appeal that you're wanting to appeal the court's order upholding the magistrate's determination of probable cause.
Correct. And I also, you never.
Do you have any authority to take an interlocutory appeal on that issue? Because appeal rights of the defendant to the Kansas Appellate Court are statutory. And that would be an interlocutory appeal, meaning during the case itself. And the statute does not call for that. So under what authority are you wanting to appeal the court's upholding the bindover by the magistrate?
Wanted a notice to appeal. I had filed that on December 21st. And also, y'all had never acknowledged my motion of dismissal.
Okay. Well, your motion to dismiss was based on the bindover, the court finding probable cause. The court has found probable cause at preliminary hearing. You have also filed a motion wanting to suppress. Are you wanting the court to take up your motion to dismiss prior to your argument on the motion to suppress?
So I had never filed a motion to suppress. I had sent the papers with y'all for the motion to dismissal. That's what I thought y'all had. And I also asked, I think her name's like Linnell, her last name started with a G, for my transcripts, which I had never got my transcripts for this date. So I didn't have the proper time for my notice of appeal to prepare because I didn't have my transcripts as well.
Did you receive the transcripts?
No, I paid for them and never received them. I had paid for them on December 10th.
Okay. Hold on while I check on the transcript.
You told me they wouldn't be ready by today.
Okay, it looks like the transcript from the October 3rd hearing is ready. And the transcript that you requested from December 9th is also ready, but you have not received those?
Not at all.
Okay. Has your email changed at all?
Not at all.
Did you check on your email because the court received a copy by email?
Yeah, she told me yesterday when I called her like that the judge has a copy, but she said I don't have a copy for you and it won't be ready until a week or two.
Mr. Becker,
I'm sorry, Your Honor, what am I to address here?
as far as the transcript,
I don't know that we've received a transcript from the December 9th hearing, but I haven't really checked to verify that.
do you have the October 3rd transcript?
If the October 3rd transcript is the transcript of prelim, then I do have that, but only because it was included as an addendum to the motion to dismiss an objection filed by the defendant.
Don't see either filed in the court as of yet. So, Mr. Crane, are you asking to continue the motion until you have received the transcript and used it to prepare?
I needed time to prepare for my appeal.
Okay, well, you're talking about two different things here. One is we had talked at the last hearing, you had filed a motion to dismiss, and the court had clarified with you what you were seeking to challenge. And you were seeking to challenge both the bind over and the magistrate, which the court was able to rule on. You were also seeking suppression of the evidence as part of it, a motion to dismiss, which we were set for hearing today. Okay,
Never filed those motions, Your Honor. I filed the motion to dismiss and the motion of objection.
okay, are you not wanting to challenge the stop then?
No, I wanted to go on, continue. I wanted my notice of appeal, and I was just waiting. Nobody had ever responded to the first motion that I had made. Y'all had said I motioned suppress the evidence and bind over, and I never filed that motion.
Okay, well, your motion regarding the bind over has been denied.
Okay.
Okay. You had also filed in that motion number 2, page 5, the search of the defendant's car and the seizure was, oh, I'm sorry, that's the response. Let me find your motion.
I had never got a response.
Well, the state filed a response. You filed your motion on November 12th.
I know they probably filed one, the state probably filed one, but I never got a response on the record.
And your issue on count 1 was you're asking it be dismissed because there was no probable cause of intent to deceive or defraud. Court's already ruled on that issue. Then you've got count 2, the possession of the controlled substance should be dismissed due to the illegal search and seizure. And that's what I've asked you is, are you wanting to pursue a motion to suppress evidence based on illegal search and seizure? You said yes, and that's what we scheduled for today. Are you not wanting to pursue that motion?
No.
Mr. Crane,
No.
you're not wanting to pursue that?
Suppress the evidence. I wasn't trying to pursue that.
Okay.
Then you said
Then you've got
well,
your third issue is the speeding infraction should be dismissed due to the absence of a written citation and notice to appear.
one more time.
Are you wanting to pursue that motion?
You repeat that for me one more time.
Your third issue on your motion, page 4, which you listed as count 3, speeding infraction should be dismissed due to the absence of a written traffic citation and notice to appear.
Right.
Are you wanting to pursue that motion?
Yes, I'm gonna keep that on there.
Okay. And why do you believe it should be dismissed? Because you were not given a notice to appear.
I was never written a ticket off, Your Honor. I was never written a ticket. When I end up coming to Kansas for my prelim, they tried to bring up my ticket when I was never written a ticket from the get-go.
Mr. Becker.
Your Honor, a traffic case, in my understanding, without having had adequate time to prepare for such an issue, can be a traffic case can be commenced by a notice to appear. It can also be commenced by filing of a complaint by the county attorney. It can also be established at prelim, as other charges can, where the evidence provides probable cause for it, as what happened here. The probable cause for speeding was established by Trooper McCord, stating that he saw the defendant's vehicle traveling 80 in a 60-mile-per-hour construction zone. That was established by probable cause at the preliminary hearing and was included in the state's amended information.
Yes, Mr.
And that was my whole point of that as well. He said he seen me doing 80, but he never gave me a traffic ticket. How did you see me doing something if you never had my speed?
Very well. Mr. Becker is correct. The state can charge you either for speeding on a notice to appear. If there are felony offenses involved, as there are in this case, they don't issue the notice to appear because they file what's called a long form complaint charging you with a crime which they've charged you with that you've been bound over on. At preliminary hearing, they also asked the court to amend the complaint to add the speeding charge. There was sufficient testimony regarding that, and so the court added the speeding charge at the request of the state.
And that was my thing. I was just asking them a question, and they made it seem like my question was like I just wanted a speeding ticket when that was never the case. I was asking them a question.
Okay, well, it's not because you asked a question. The state has the right to amend the complaint to charge you with whatever crimes there is evidence to support.
Okay.
Then you can challenge that at the time of trial. You understand that?
No problem.
Okay, so your motion to dismiss the speeding infraction is denied. Those were the three things you cited in your motion. Is there anything else you have filed?
That'll be it, Your Honor.
Pardon me?
That'll be it besides my notice of appeal.
Okay. Now, back to your notice of appeal. Do you have any statutory or case authority that allows
That's
you to
my
pay?
constitutional right for my motion to be heard, Your Honor.
Okay, well, that can be filed at the end of the case. You have
Why would it be filed
prematurely,
at the end of the case?
well, you prematurely filed your motion for appeal because you don't have the right to an interlocutory appeal. But if you file your notice early, then the court can accept it later as your notice, but you should still file an appeal should you lose your trial in this matter, okay?
When you say early, I filed it December 21st.
Okay, well, but it's not ripe for appeal yet because this would be an interlocutory appeal and you do not have the right to an interlocutory appeal on preliminary hearing bindover. So you're early because you don't have that appeal right yet. So where we're at is we need to do an arraignment based on your bindover. Are you ready to do arraignment?
And I get some more time for arraignment or
Well, arraignment is what starts the clock going on setting your trial and bringing this matter before the court.
okay.
Okay,
So
why do you need additional time before arraignment?
because I needed some additional time for my arraignment because my first motion, well, You're right. My motion was denied, so you can carry on. But I wanted my transcripts as well. That's why I wanted more time.
All right.
I wanted to have everything before I went into my arraignment.
Your motion that you had filed back on November 12th included the transcript of preliminary hearing. You included that as part of your motion, so obviously you have the transcript.
I'm talking about the transcript from our last court date that I paid for.
The last
Never
hearing is
received.
simply the court's denial of your motion to dismiss based on the probable cause finding of the court. And that has been prepared and you'll receive that shortly. But that does not impact arraignment,
Okay.
okay?
Your Honor, just for clarity, I would like to ask the first part of the motion, depending on probable cause for identity fraud, that was ruled on at the last hearing. The motion to dismiss speeding is denied at this hearing, I think you've already said. As for the second part of the motion regarding the search and seizure of objects from the car, has the court ruled on that, or is
The defendant is withdrawing his request to challenge the search and seizure.
okay?
Correct, Mr. Crane?
All right.
You need to answer yes or no, please.
Yes.
Yes. Okay, so he's withdrawn the second part on the search and seizure.
Okay, thank you, Your Honor. So it's the state's understanding that that whole motion has been ruled on at this point. Okay.
Yeah. The court has ruled on the first issue and the third issue. The second issue is withdrawn by the defendant.
Okay, thank you, Your Honor.
Okay. And Mr. Crane, you've received a copy of the amended information in this case?
No, I don't think I have a copy.
Okay.
You can read it.
Can you see that?
Mm-hmm.
Okay. At arraignment, I can read that to you word for word, or I can summarize it for you. Which do you prefer?
You can summarize it.
Okay. Count one charges that on or about June 20th of 2024 in Ellis County, Kansas, you did feloniously alter, amend, counterfeit, make, manufacture, or otherwise replicate a document containing personal identifying information with the intent to deceive. That's identity fraud. That's a level 8 non-person felony.
Level 8. Let's see it.
Okay. On a level 8, the minimum punishment is 7 months to a maximum punishment of 23 months under Kansas sentencing guidelines. If you have 2 or more prior person felonies in your background, in your conviction history, then it becomes presumptive imprisonment. If you do not have 2 or more prior person felony convictions in your background, in your criminal history, then you're presumptive probation. You understand that?
Right.
Okay. On a level 8, you can also be fined up to $100,000. Understand that? Okay. So do you understand what you're charged with in count one?
Yes, sir.
How do you plead to count one?
One.
You can plead not guilty, or you can refuse to enter a plea and the court will enter a not guilty for you. Are you
Guilty.
not guilty?
Well, I don't want to enter a plea. You're right. I don't want to enter a plea.
You want to stand mute and not enter a plea? I'm sorry, you need to answer out loud.
Correct.
Okay. So you're standing mute. And so the court
Your
enters,
Honor,
the court enters your plea of not guilty on your behalf since you're standing mute.
okay. And, Your Honor, on that second motion, instead of withdrawing it, I'll just wait to see if y'all deny it or accept it. That's my last time. I just wanted to say that on the record. I'm sorry about that. On the suppressed evidence.
Well, are you wanting to have a hearing on the suppression?
Yes, we can have a hearing on
Are you prepared to do that today?
it today, Your Honor.
Or do you need time to prepare that?
Yes.
How much time do you need to prepare your motion?
Can I get 2 to 3 weeks, or that's too long?
Court could give you a couple of weeks. Okay, so Mr. Becker, we're not going to do arraignment. We are going to back up and do his motion to suppress.
Okay.
Okay, on the second issue he filed. Jess, we need to find a time here in a couple of weeks.
Judge, how much time do you anticipate needing for that hearing?
Mr. Becker?
Is it still the plan to just have the motion to suppress on stipulated facts from prelim, or?
Mr. Crane, are you going to rely on the preliminary hearing transcript, or do you want to present evidence?
Can I get the transcript from, well, I don't need the preliminary.
Well, you
You're
have
right.
the transcript. You included the transcript in your motion.
Yeah, I did. I said I included it, so I used the transcript and I used some evidence.
So you're wanting to use the transcript, or you want to present evidence? Mr. Crane,
I said both. You can hear me?
I can't hear you. You need to take your hand away from your mouth.
I said both.
Okay, so you're going to present evidence. How long do you need for that hearing?
You can give me 4 weeks.
No, we're doing it in a couple of weeks. How long of a hearing do you need? Do you need 30 minutes? Do you need an hour? How much evidence do you plan to present?
Both.
Probably 45 minutes.
Mr. Becker?
Your Honor, I would set it for an hour. I don't think that it would probably take the whole time, but just out of an abundance of caution, I think an hour would be sufficient.
Yeah, Jess, I would look for an hour to 90 minutes here within the next couple of weeks.
Judge, on the afternoon of January 16th, you would have time starting at 3 o'clock.
I'm in recovery court that afternoon.
Okay, I couldn't remember if you were involved with that or not. The morning of the 23rd, Judge, you could start at 10 o'clock.
I have a prelim that morning, I'm sorry.
No, that's okay. Judge has time that afternoon as well, starting at 3.
My afternoon's free that day.
Does that work for you, Mr. Crane, on January 23rd at 3 p.m.?
It's a Thursday.
Yeah, we can do that.
Okay. So January 23rd, 3 p.m., we will take up your second issue in your notice to dismiss, which is the suppression of evidence.
Okay.
Okay? Anything else today then, Mr. Crane? Anything else today, Mr. Becker?
No, Your
Couldn't do
Honor.
nothing with my notice to appeal, correct?
Okay, I've already ruled on your notice to appeal. You're asking to take an interlocutory appeal to the appellate court. That's not provided for by statute. So your motion to appeal right now is denied. The court will just have it sitting there in the file as file premature from any ruling on the trial itself. You can take up that issue, but not till the case is concluded,
Okay.
okay? Mr. Becker, will you do an order?
Yes,
Okay. And we will see you all on January 23rd at 3 p.m.
and Your Honor, I will do a motion, an order also on the denying of the motion to suppress the speeding count.
Right, in the
Well.
journal entry, you would just indicate the court had already ruled on his first issue. The court denied his third issue. We'll set for hearing the second issue on the suppression for January 23rd at 3 p.m.
Okay, thank you, Your Honor.
Okay?
Okay.
Anything further then, Mr. Becker?
No, Your Honor.
Anything further, Mr. Crane?
No, sir.
Okay, Jess, are we using the same Zoom coordinates on the 23rd?
Yes, Judge. Mhm.
Okay, so same Zoom coordinates, Mr. Crane.
Will you email for it again or no?
What's that?
I'll send it back out to you, yes.
Problem.
Okay. Okay, thank you all.
Thank you, Judge.
Be safe, be well, sleep sweet, and much love.